For over 2 centuries, Americans, lawyers, and government operated under a shared understanding that the Second Amendment protected individual rights to keep and bear arms. For most of American history, federal and state governments imposed minimal regulations on firearms ownership. Thus, there was little reason for Second Amendment lawsuits. The landscape began changing in the 20th century as groups began promoting increased firearm regulations and governments began responding with more restrictive laws. It is worth noting, the Second Amendment didn't change, nor was the Constitution amended. This shift created conditions requiring Supreme Court intervention to clarify what had been previously understood through shared cultural and legal tradition. When the Supreme Court finally addressed the core Second Amendment question in Heller, it validated the 200-plus-year-old original consensus. The court clearly stated that the Second Amendment protects a fundamental right grounded in the right to self-defense. The historical evidence the court provided included Blackstone, Wilson, Tucker, and 19th-century state court decisions to show consistency in the original Second Amendment understanding that it protects individual natural rights. The Heller opinion made 4 references to the Declaration of Independence and recognized the natural law foundation of American government with the following quote: "When in the course of human events, it becomes necessary for one people to assume among the powers of the earth the separate and equal station to which the one laws of nature and of nature's God entitle them." The Second Amendment addresses both individual and collective dimensions of the rights to life, self-defense, and to bear arms. At the individual level, it protects the means by which citizens can defend themselves, their families, and their property, the practical mechanism for exercising the right to self-defense. At the collective level, through the well-regulated Militia Clause, it recognizes the people's right to defend their community and resist tyranny, protecting the collective right to life and liberty of the political community. The 2008 Heller case involved the District of Columbia. The district has a unique place in American law, as directly controlled by Congress. The Supreme Court still needed to affirm that Second Amendment protections applied to state laws as well. In the 2010 case of McDonald versus Chicago, Illinois, the Supreme Court affirmed that the Second Amendment applied to state and local governments through the 14th Amendment. This extended the constitutional protection of the natural right to self-defense to all levels of government.